The next matter to come before the court is State of Ohio in relation to Jack Morrison versus Clarissa. Is it Wiener or Wiener?
Wiener.
Okay. As you know, each side will have 15 minutes to present oral argument. The appellees, do you both intend to present oral argument?
Yes.
Okay, you'll have to share the 15 minutes. And you've read the briefs and you're prepared to proceed with the testimony.
Thank you. May it please the court, Your Honors, my name is Mark Burnmore. I represent the defendant appellants Clarissa and Mike Wiener. I'd like to reserve 3 minutes on rebuttal if I could.
Yes.
Before going to the assignment of error, I'd like to take a few minutes to describe the context, kind of background of this case. This is a playhouse that's in progress. In fact, taken a picture of a couple of playhouses that are involved in this Steeplechase Homeowners Association. The first picture is, we'll start with the lower right, is the Wiener's Playhouse. The second picture is Mr. Scanlon's playhouse, the playhouse on his property. I don't know if he uses it, but it's the playhouse on his property. The picture up here depicts the minor playhouse. The minor playhouse is 19 feet tall. It has electricity that goes to it. It has carpeting. Chris Miner was on the review committee that met to decide that this house did not comply with the homeowners association restrictions, but this house did, even though it's much larger, taller, bigger, has electricity, carpeting, and so on.
Let me interrupt for just a moment. I'm presuming that all of these documents were admitted in evidence.
That's correct.
Okay. Okay.
The Conti Playhouse is another playhouse that's quite large. It's 13.6 or 13 feet 6 inches by 16 if you include the slide. If you don't include that, it's 13.6 by 10. The height is 13.6. It's not attached to the house. The main house, as well as this one, is not attached. Thomas Conti was on the Board of Zoning Appeals at the time that he went to the City of Monroe Falls Building Department, was told that he did not need a building permit. And I just point these out to you as free representative structures at the Homeowners Association. There are 17 total that are outbuildings that are similar in nature, 7 of which are owned by either board members or former board members of the Steeplechase Homeowners Association. There's roughly 150 homeowners, so we're talking about roughly 11% of the homes in the Steeplechase Homeowners Association that have outbuildings. So the question is, how did we get here over the Playhouse case?
Excuse me, I have a question. If an outbuilding is to be approved or put up for approval, is there a square footage maximum? In other words, before they will approve, it has to be small enough or within a certain range of square footage.
Your Honor, I would be lying if I knew the question, or if I threw the answer out to you. I just don't know.
You don't know, okay.
I don't know the answer to that.
Because all of those look pretty fancy, and I'm just wondering
Yeah,
whether that was in the code.
and I'll touch on that a little bit later,
Yeah, I
but
wouldn't think anybody-
rather than try to cloud you like I know the answer, I'll touch on that later. The summer of 2012 was when it all began, when Mike Wiener went to the building department to get a building permit. It just so happened that while he was at the counter, a gal, and we only know this in hindsight, by the name of Ann Nicola, was walking past and made the comment, "You can't get a building permit for that because it's against the Homeowners Association deed restrictions." He was turned away without even getting an application. Ms. Nicola later testified that she was acting as both the service director for Monroe City Building Department and as a former officer, I believe president, in a present member of the Steeplechase Homeowners Association. In other words, she was wearing both hats. Mike Wiener then went back. A number of things happened. What we know now is that there's a dozen communications between the City of Monroe Falls and the Steeplechase Homeowners Association about how to handle this situation. Steeplechase wanted City of Monroe Falls, mainly because of the cost, wanted them to prevent the Wieners from going forward with the playhouse. At the same time, Morrison becomes involved. And anything I say about Jack Morrison is, not personally, it's with his hat as the city law director. He becomes involved. Things obviously get to the point where a lawsuit's filed to prevent the construction of the playhouse. Subsequently, in December of 2012, the Wieners finally obtained the building permit which permits them to build the playhouse. It's the only type of building permit that's required. We have testimony left and right about this is a building permit that allows the construction of the playhouse. The building permit says, upon examination of the above information, zoning maps, ordinances, and laws, I do approve this permit given for land or indoor building use. And that's to be used for playhouse 10 by 10 accessory building. So in December, we believe this case is over with. 3 months later, in March, we received a letter from Jack Morrison that says, okay, you've got the building permit, but you're going to have to comply with the Steeplechase Homeowners Association deed restrictions, and until you give us a waiver of those private deed restrictions, you can't build, even though we've already got the building permit from the municipality. So that sets off a firestorm because we believe the law is very clear that a municipality has no business enforcing private deed restrictions involving a homeowners association. That's kind of the central issue to us in this case. After that, we asked for the TRO to be vacated, and the court denies that. We then have this appeal process because we believe the substantial right was affected by the denial of the injunction because time is running, and the two Wiener girls aren't allowed to use their playhouse because it was in mid, even though it looks completed, it's not completed. And the Court of Appeals correctly decided that there was no jurisdiction at this point in time. It wasn't a final appeal award. We then go back, the case is reactivated, set for trial in, I believe August of 2015. Just prior to that, motions for summary judgment are filed by both, the plaintiff and the third-party defendant. Going to the merits of the assignment of error, the first issue involves the fact that the conspiracy claims were dismissed. The premise of the dismissal of the conspiracy claims were that the underlying tort was not specifically pled, and therefore our conspiracy claims on their face against the Homeowners Association and the City of Monroe Falls must be dismissed. On its face, that makes sense, except for the fact that the cases relied upon by the trial court involve underlying torts that do need specifically pled. RICO, fraud, governmental action. Those three types of cases and those underlying torts that make up a conspiracy claim do have to be specifically pled because in and of themselves, independently, they must be specifically pled. But what we were claiming was that there was improper governmental taking of property, which we believe is quite clear that you cannot, that the government, when it stands in the shoes of preventing an otherwise proper construction, that's taking of property. I think we've set forth law on that issue.
In reading the court's opinion, I walked away with the impression that the court not only was looking at this case law, but also was just looking at notions of, even under notice pleading, due
through each of the paragraphs of the amended counterclaim, or not the amended counterclaim, the counterclaim, and describe for you, but you can read also, but I will.
And we will.
Yeah, I don't, I guess my bottom line is I don't buy that. I mean, we have said the HOA has acted with actual malice toward third-party plaintiffs by continuing to interfere with their completion of the playhouse and their property. And the HOA and the city of Monroe Falls have conspired to deprive the third-party plaintiffs of the use and enjoyment of the property. Now, that's improper taking. That's government taking the property. As well as, now, let's talk about slander of title. In the intermediate period of time, Jack Morrison decides that he will do a $53,000 special assessment against the homeowners for failing to comply with the TRO. And he contacts Summit County, and there's actually a lien on the property right now. That all arose well after, in fact, 2 years after the counterclaim was filed. But still, the counterclaim alleges, underlie, the fact that they have deprived us of the quiet use and enjoyment of our property. They've continued to maintain an action which should not be maintained, which goes to the abusive process. And we've got an ongoing, I mean, if Rule 15 allows amendments of pleadings, at trial or even after, and we've got discovery that did not even occur until the summer of 2015 because of the posture of this case, everybody knew what was, I mean, there was no surprise.
Were there amendments made?
There were no amendments made because a motion for summary judgment was filed 3 months before trial. I mean, the case was reactivated in January, February 2015. They wanted to get going, the case was getting old. It was set for trial, I believe, in August of 2015. All the discovery took place after it was reactivated in the summer of 2015. That's when we found out about all these emails between the HOA and the city of Monroe Falls. That's when everything kind of happened. I can't recall the exact timing between the case was on appeal, but the fact of the matter was that under your holding in the case of Right Safety versus U.S. Bank, which is in the briefs, as you know, this Court of Appeals found that in looking at the allegations in the complaint, and this one was a lender liability case in which the borrower was claiming conspiracy. The trial court kicked it out because it said that you didn't allege the underlying tort. And this is what this court held. It does not appear from the entry that the trial court considered the possibility that the Wright companies and Mr. Wright's civil conspiracy claim itself might have included allegations constituting an independent tort. So I stress, might have included allegations constituting an independent tort, and thus satisfying that element of a civil conspiracy claim. Wright companies and Mr. Wright allege in their civil conspiracy claim that U.S. Bank and its employees applied payments received from Wright companies and Mr. Wright in an improper manner in order to maximize U.S. Bank's receipt of default interest and in order to cause a default on the promissory note, and that such action taken in concert with John Doe defendants numbers 1 through 10 constitutes a conspiracy in order to bring about an unlawful default. Thus, we sustain Wright companies, Mr. Wright's assignment of error, and remand the case back. So,
Let me interrupt just to let you know that you are into your reserve time now.
okay. Well, I'll just merely comment on the waiver. I don't know what else we could have done to prove waiver. It's all on the record. The court seemed to stress the fact that there's a non-waiver provision in the deed restrictions. And I'm driving it here this morning. How would you ever prove a waiver of a non-waiver provision, even though you've proven all of the underlying waivers? It just makes no sense, and the law is not required in a context of deed restriction, waiver of deed restrictions. So I will reserve the rest of my time for rebuttal.
You've got just under a minute.
Thank you.
Good morning, Your Honors. May it please the court, counsel. I'm Tom Sachs, I represent Monroe Falls in this litigation. Unlike Mr. Bernlohr, I think this case is very simple. The facts are very straightforward. In early 2012, the Wieners wanted to build a playhouse. They asked several times the homeowners association, can we do it? They're told, no, you can't. Not Not deterred, they began construction.
Why
Monroe
were they
Falls,
told they couldn't?
I'm sorry, Your Honor?
Why were they told they could not?
They were told it violated deed restrictions. They began to build anyways.
So these other ones that are already existing don't violate the same deed restrictions?
I don't have any opinion on that, Your Honor.
Okay, all right, thank you.
Monroe Falls discovers they're building it, the zoning inspector comes out and tells them you have to come down and apply for a zoning certificate. They say they'll do that, they don't, they continue to build. June 8th, 2012, we file a stop work order, they ignore it, they continue to build. We're in communication with their attorney at the time, Noah Munier. We tell Mr. Munier we're going to file for an injunction if they don't stop. He says they want to comply, can we work this out? We said we'll give you time. We enter into a series of stipulations with them. Amended record document number 6. They stipulate that they're in violation of Monroe Falls ordinances by not having a zoning certificate. They stipulate that the construction is a nuisance per se. They stipulate that they'll come into compliance within 30 days or they'll remove the structure, and if they don't, we can't. That forms the basis for this lawsuit. We take those stipulations, we draft a stipulated injunction, we file our complaint, we file the stipulations, the court enters the injunction. 30 days is running. Hindsight's 20/20. They did nothing in the 30 days. Their answers to interrogatories, amended record document 132, established they didn't even come down to get the application until the 31st day. And that was because we called and said, you haven't complied, when are you going to take it down? In a panic, they fire Mr. Munier, they hire Mr. Bernlohr. Mr. Bernlohr's approach appears to be, best defense is an aggressive offense, so I'm going to sue you. Files a counterclaim for conspiracy, brings in steeplechase, files a motion to vacate the stipulated injunction. We have a full day evidentiary hearing in July of 2013. September, the court issues its order. Finds number 1, you haven't obtained the zoning certificate. Number 2, you haven't even submitted the application. It's appealed, we go back down, and we continue discovery. Most important piece of evidence that came out during that discovery is Clarissa Wiener's deposition. April of 2015, the transcripts, amended record document 146. I'd urge you to read 21 to 31, those pages. Painstaking questions. Mrs. Wiener, what did anybody from Monroe Falls do with anybody from Steeplechase? Because the only claim against Monroe Falls is conspiracy. What did anybody do to prevent you? Her answer at one point says, well, I'm waiting for you to tell us. And I tell her, well, it's your case, it's your burden of proof. And she says, well, consistently to every question, we don't have any facts. 2.5 years after they filed a counterclaim. We file our motion for summary judgment. It's granted. We're here with 4 assignments of error. Only 2 relate to Monroe Falls. Those are the only 2 I'm going to address. And I think the first assignment of error actually is irrelevant. First assignment of error is a pleading deficiency. Trial court held you didn't plead the underlying claims. You waited until you responded to the summary judgment motion. That's inappropriate. They rely on the Wright case. I think Wright's factually distinguishable. Look at the Wright case and look how detailed the allegations in the pleading were. It alleged the underlying conspiracy. Here, there's only conclusions that there was a conspiracy, no facts. But the reason I say this assignment of error is irrelevant is because the Wright court, as Mr. Bernlohr indicated, remanded it back to the trial court and said you really should have addressed their claims. Page 4 of the trial court opinion, that's exactly what the trial court did. The trial court said, even if I look past your pleading deficiency, I'm going to address your 3 claims. Abuse of process, taking a property, slander, title. You don't have any facts to support them. That's their second assignment of error. The trial court found they didn't have any facts. Again, Mrs. Wiener's own testimony establishes they don't have any facts. But if you look at what's out there, it's clearly supported. The first claim is abuse of process. Their argument is that we took this seemingly legitimate lawsuit and it was a ruse for us to enforce deed restrictions. Look at our complaint. Steeplechase is not mentioned. Deed restrictions are not mentioned. The only thing that's mentioned is a violation of Monroe Falls ordinances that they stipulated that they violated. The law of conspiracy is very clear. It's a malicious combination of 2 or more persons to injure another in a manner not competent for one alone. The law is clear. You cannot conspire to do that which you are legally entitled to do.
Well,
We are,
let me just ask you how this comparison of these photos plays into the intent of the city. In other words,
I don't think it does, Your Honor. I don't know that we even knew those existed. We do not make an independent.
well, how did they get before the trial court? I mean,
Mr.
it's
Bernard took photographs and admitted them,
Right.
but they don't have anything to do with our
And so
enforcement
at what-
ordinances.
At what point in the litigation were those before the court? You said, when you were asked by Judge Whitmore about the comparison, you said, I don't have a comment on that, I don't know.
I'm not enforcing either system, I'm enforcing ordinances. They are building in violation of an ordinance, they stipulated that they're building in violation of an ordinance. I have every right, if not every obligation to the citizens of Monroe Falls to enforce those ordinances. They have not complied, they stipulated, there should be a stop from presenting this argument because they stipulated that they were violating our ordinances. Their second claim is taking a property. They say this is an accessory building, we live in an R4 district, it's allowed. I'll concede it's an accessory building, I'll concede it's an R4 district. That's not the end of the analysis. Under their logic, they could take this house and they could put it right in the middle of the sidewalk. Clearly, that's not allowed. Other ordinances apply. You have to give us a 2-scale drawing. You have to show us the location of the structure. They haven't done that. If you look at our brief, page 10, footnote 1, you will see in late 2012 and early 2013, we are asking them, I'm writing Alan Medbeck, the previous attorney, give us, you haven't submitted the application, just give us the drawings and we'll try to work with you. They send us a drawing and we say, Alan, this is a picture out of a magazine. Oh, yeah, here's a drawing. Alan, wait, this doesn't show the porch. We know it's not accurate. Yeah, you're right. Here's another one. You'll see those back and forth. 7 months later, the trial court, in its order, after the full evidentiary hearing in July, says, you still haven't submitted the documentation they need. There's no taking a property. They fail and refuse to submit what they're obligated to submit. There is no taking a property. Slander of title. That fails as a matter of law. Their allegation is that we improperly assessed their property. The issue before you, Your Honors, is not whether that assessment's proper or improper. The only claim against us is conspiracy. The issue before you is whether we conspired with Steeplechase to levy an assessment. They admit at page 24 of their brief. No evidence that Steeplechase was involved in the levy of assessment. There are no facts to support the levy. The Steeplechase was involved. And as a matter of law, because there are not two actors, there cannot be a conspiracy. The trial court found there were no facts to support their claim, even looking past the defective pleading. Mrs. Wiener, again, her testimony, over and over, I have no facts to support that. You'll see if you read that. I asked her, this person and this person, and this person and this person, do you have any facts? Anybody did anything? She said, no, I don't. The trial court properly found there was no conspiracy. We would ask you to affirm the trial court's decision as it relates to Monroe Falls. We filed a motion for frivolous conduct to seek attorney fees. That was stayed pending this appeal. We would ask you then remand the case back to the trial court so that can be addressed. Thank you.
Good morning. I'm Larry Scanlon. I represent the Steeplechase Homeowners Association, who was brought in after the fact by the Wieners on a third-party complaint alleging, among other things, conspiracy and failure to properly enforce our own restrictions. We weren't served for 6 months after that case was filed. And the argument you heard today is only partially correct in terms of what's out there in the development. Quite frankly, until we were forced to follow along on subpoenaed inspections, this voluntary board didn't necessarily know about everything that was out there. One of the arguments you heard was that there are 17 violations. Well, first off, that's flat out incorrect. Number one, they double counted one, so we're down to 16. The only two they can put up that looks like houses, that's what they put up. The rest are decks, gazebos, unattached structures, or play sets, like ours, or like theirs. No one said that play set, which is very large, violates our restrictions because they're permitted. But this is what that playhouse really looks like. Exhibit 5 in our brief. That's me. This is a small house. It has insulation, power, light, heat, air conditioning, a metal door, a lock, screens, a loft, recessed lighting. It has everything but a commode and cable. It's a house, period.
How is that different? How does that differ
Exactly.
from some of these other ones?
They're not insulated, they're not meant to be habitated. Mr. Conti's is up in trees on stilts, so is the minor playhouse. Voluntary boards, as such, do what comes in front of them. Clarissa Wiener sent an email to the current president, Barbara Hoover, and said, we want to build this house, here's our plans. And it was really just the manufacturer's rendering of what it was going to look like. Barbara looked at it, consulted with the board, said this violates our restriction on any unattached storage buildings, outbuildings, accessory buildings, sheds and barns. They said, well, we don't have those restrictions. Well, they sent them to her. She said, oh, I do have these, because they're attached to their title. It's given to them when they move in with their homeowner's welcome package. So she did have it. She did know what the restriction was. And Barbara then said, well, let's look at this. We'll have a review committee from the board and determine whether or not we can proceed. Now, this is all before construction's begun. They're told, no, you can't build it. It violates our restriction. They did anyway. No, their attorney, 2 days before he solicited a agreed journal entry, a stipulated entry of fact with the city, contacted Barbara and said, is there any way around this? Can we attach it to the house in any way? Barbara said, you'll have to take that up with the city. That's not up to us. As it turns out, once we went out and did this inspection, it violates the city setback, it violates our own setback as far as where it sits on the property. But the point really is that there's a non-waiver provision that the court cited at length for this very reason, for the argument you're hearing right now. And it says, failure of the steeplechase to enforce any of the restrictions contained herein shall in no event be construed to be in any manner a waiver of, or acquiescence in, or consent to a further or succeeding violation of these restrictions. However, the failure, refusal, or neglect of the steeplechase to enforce said restrictions or prevent violations thereof shall in no event make the steeplechase liable for such failure, refusal, or neglect of any third party or person. So it was clear that understanding that this was going to be a group of voluntary board members, people are homeowners, that will change from time to time, what they become aware of or what they don't become aware of. They shouldn't be held by whatever some other preceding board failed to do.
Is the finding of a waiver a factual finding?
It is, I think, determined as a matter of law here. The court looked at all of the evidence that was put before, including these alleged violations, which are not. Play sets, decks, gazebos don't violate that. They don't. They don't substantially change the nature of the neighborhood. Not like in the neighborhoods around us where you drive down the street and everybody has a shed in the backyard, or a house or a playhouse. But there are not 16 buildings like theirs. At best, they have those two. That's it. And when homeowners do the right thing, which is to approach the board and ask, can we build something, action has been taken. Committee looks at the records, looks at the drawing, says yes or no. In fact, when we found out in this inspection, because we weren't walking through everybody's yards, that people had something in violation, we sent them letters and they complied. And people who had submitted plans historically were told no, they complied. These folks were told no 3 times, and once before, at least once or twice before they started building, built anyway.
Do I understand that the photos that are being used for comparative purposes are not in violation of the homeowner's restriction? Is
Well,
that your position?
they're up on stilts, they're tree houses, they're playhouse types, I mean, they're open windows, windows, one has closed windows, but they don't have anything like this. At best, I would say, maybe the minor house could violate it, but not the Conti house. It's a tree house. It's up in the tree line.
Somebody talked about insulation. Why should that be a determinant?
Because it's habitable. It's an
Well, the others
accessory
look like
building.
they're habitable too. I mean, from my perspective, the one that you make note on the
Right.
left, it's pretty big. You could live in there with a sleeping bag.
One house, 152. That's not a substantial change, Your Honor, under the case law, so that our restriction has been waived. And in the event there is some question in your mind, we had a non-waiver provision exactly for this situation, where someone is being bootstrapped from the past and saying, well, you're singling us out. And on top of it, they claim this is a conspiracy.
And I regret to inform you that you've reached the end.
Thank you, Your Honor. I appreciate your patience.
Absolutely. We're going to
Thank you.
go under a minute.
Yeah, and you just wrote it straight. Wait a second. On the timeline, there was agreed upon stipulation. It's September of 2012. In December of 2012, the building permit was issued. So that's it. We're done. It cost her her job. The person who issued this was fired the next day because apparently there was miscommunication and she shouldn't have issued it. But a building permit was issued.
Is that in the record?
Yes, absolutely. It's all very much in the record. In March, when Jack Horson sends us letters saying, hey, you know what? You've still got those deed restrictions to tangle with. He doesn't say anything like there's anything else that we have to do. The only thing we had to do was to adhere to the deed restrictions. Before the city can approve of the structure as it currently exists, Mr. and Mrs. Wiener will need to obtain a waiver of the deed restrictions. That's the only thing that was left. Well, guess what? The deed restrictions say right in them. Therefore, you must consult the zoning code, which changes from time to time prior to proceeding with any regulated conduct. Violation of these restrictions may only be pursued by a lot owner or owners. The city or village cannot enforce them. And it's in there because that's the law. You can't, Jack Morrison can't enforce steeplechase deed restrictions.